When confronted with the breach or the alleged breach of a non-compete or non-solicit agreement, one of the first questions that begs to be asked is this: what are the potential claims and liabilities here? Simply put, in order to assess accurately what actions you should take, regardless of which side to the case you're on, it's imperative that you know going in what the potential claims, defenses, and damages are. That said, let's analyze briefly what those potential claims are under New York law. Generally speaking, there are 9 broad categories or types of claims that may arise from the claimed violation of a non-compete. 1. Breach of contract. This is self-explanatory and typically involves the specifics of the employment agreement, including the non-compete and non-solicitation provisions of the contract. 2. Breach of duty of loyalty. Even at-will employees that don't have any employment contract are ethically and legally bound not to do anything to actively harm their employer's interests. 3. Aiding and abetting breach of duty of loyalty. This too is largely self-explanatory. The point to bear in mind here is that under the right conditions, New York imposes liability on those third parties who affirmatively assist employees in breaching their fiduciary duties to their employers. 4. Tortious interference with contract. This cause of action relates to, most commonly, the former employer's existing contracts with customers that were breached. 5. Tortious interference with prospective advantage. This relates to prospective customers or clients with whom the former employer did not have an actual contract, but had a reasonable and tangible expectancy that they would enter into a contract with them in the future. 6. Defamation. This category typically arises from the claim that the former employees badmouthed the former employer, causing harm to the former employer. 7. Unjust enrichment. This claim typically focuses on areas where there is no contract, or the contract is unenforceable for one reason or another, and the defendants apparently benefited from something that rightfully belonged to the plaintiff, such as the plaintiff's proprietary materials. 8. Conversion. Similarly, albeit slightly different, conversion is where a defendant exerts control over the plaintiff's property and interfered with the plaintiff's right of possession of that property. In this context, that could include the plaintiff's proprietary information or client list. 9. Unfair competition. Finally, this is the catch-all category which includes any form of commercial immorality, where the defendants piggy-back and unfairly take advantage of someone else's work product without paying for it, and then use that information to compete with the plaintiff. Naturally, this is just a very brief overview of a much broader topic. If you have any further questions regarding your non-compete or non-solicit and the possible claims arising from that, please pick up the phone and give us a call at 516-791-5700 or toll free at 888-497-3410. This is Jonathan Cooper, and thank you for listening.